today's session is on the question, how will the new Procurement Act affect public sector buyers? And that is a deliberate choice of words. This webinar is focused on buyers, on contracting authorities. We have another webinar in a couple of weeks that looks at the Act from the perspective of contractors and suppliers, so the people who are actually selling things to public authorities. If you're a contractor or supplier, I'm sure you'll still get plenty out of today's session, if only an insight into how authorities think about these sorts of things. And likewise, attending today, if you are a buyer, you may nevertheless find it useful to attend in a couple of weeks' time. So we'll come back to that at the end, and you'll get a link to sign up to that second webinar if it's of interest to you. In terms of who we are, so I'm Charles Livingstone. I'm a partner in the Risk, Government and Compliance team here at Brodies, and I'm the head of the Competition and Procurement practice. And I'm joined today by Jamie Dunne, who is a senior associate in that practice and that team. And we've each been helping clients navigate the transition to the new Procurement Act. So I think our numbers have stabilized a little bit. So without further ado, we will move on. So what we're going to cover today, I'll give you a bit of an introduction. I'll then speak about which bodies are covered by the Act, and that includes a little bit on what about Scotland. We have a mixed audience in terms of Scottish and non-Scottish public authorities, so it'll be relevant to the Scottish public authorities in the room. Those of you who are not Scottish, don't worry, we won't be dwelling on that for too long. I'll then hand over to Jamie, who'll speak about the timings, the key changes, and what the Act means for litigation before it comes back to me to wrap up and to deal with the Q&A. So on our next slide is the introduction. This is essentially what the new procurement regime is made up of. You have the Act, which comes into force on the 28th of October and will apply to procurements commencing from that date, with some wiggle room around that, which Jamie will cover. The procurement regulations come into force on the same date, and they make lots of detailed provisions about transparency and notice requirements and other things. And there are then 48 guidance documents, as if preparing for the new Act wasn't time-consuming enough. And this new regime replaces the public contracts regulations, concession contracts regulations, utilities contracts regulations, and defence and security public contracts regulations. So it's essentially now a one-stop shop rather than having lots of different procurement regimes. Although perhaps unhelpfully, there is now to be a different procurement regime for health procurements in England, so not quite the one-stop shop that was promised. On the next slide, you can see how the applicability of different regimes applies to different authorities. So any contracting authority that is based outside Scotland and is operating outside Scotland will be governed by the Procurement Act and accompanying regulations, and any litigation will take place in either the High Court of England and Wales or the High Court of Northern Ireland. What we've described as our UK contracting authorities who are buying in Scotland, so UK government, for example, operating across the UK. If buying things in Scotland, that will still be covered by the 2023 Act and the 2024 regulations, but any litigation would be in the Court of Session. That's potentially quite a significant difference from the previous regime, and Jamie will come back and touch on that. There's then our third category of devolved Scottish contracting authorities who, subject to some exceptions that we will come back to, will not be governed by the 2023 Act, but will continue to be governed by the Scottish versions of the various regulations that I reeled off on the previous slide, as well as the related 2014 Procurement Reform Act. And given that that's a continuation of the current regime, it will remain the case that litigation can be brought in the Court of Session or in the Sheriff Court. So moving on to the question of which bodies are covered, the high-level term is contracting authority. Those are the bodies to which the Act applies. And being a contracting authority means being either a public authority or in relation to particular contracts that qualify as utilities contracts, a public authority or a public undertaking or a private utility. You can see there's lots of color coding on this slide just to try and help you connect the dots in terms of its definitions within definitions. It's a little bit of a Russian doll when it comes to the interpretation of who's caught. So we'll break those down. So a public authority, a body will be a public authority if it is either wholly or mainly funded out of public funds, or it is subject to public authority oversight. And the color there is a clue that we will unpack that term. And in either case, it does not operate on a commercial basis. So a public authority is either wholly or mainly funded out of public funds and not commercial, or it's subject to public authority oversight and not commercial. Of course, it can be both, funded from public funds and subject to public authority oversight. It's the easiest category. So we'll before we go to the other definitions, we'll unpack those terms. So in the next slide, we have what it means to be subject to public authority oversight. That is relatively straightforward. It means being subject to management or control by one or more public authorities, or by a board, more than half the members of which are appointed by one or more public authorities. So hopefully that makes sense. And then the question of whether a body operates on a commercial basis, there is a quasi definition in the Act. I say quasi because what the relevant provision says is it begins with examples of factors to be taken into account in determining whether a person operates on a commercial basis include the things stated in the Act and on the slide. So whether the body's losses would be borne by a public authority, or its continued operation would be secured by a public authority directly or indirectly, whether the body contracts on terms more favourable than those that are reasonably available to bodies not associated with a public authority, and whether it does or does not operate on a market that is subject to fair and effective competition. Now, these are, while they're phrased slightly differently, if you've been involved in procurement in much detail, you'll recognise these criteria as forming part of the test of whether a body is a body governed by public law for the purposes of being a contracting authority under the existing procurement regime. So don't anticipate the test being different, but it obviously is worded slightly differently. So if we go back to the slide with the broader categories. So yeah, the public authority definition is hopefully going to be relatively straightforward in most cases. I'm conscious we do have quite a few people in the audience who are from universities. As I said, the test is not necessarily different from under the existing procurement regime. Universities, however, are or at least some of them are in a bit of a grey area, can be in a bit of a grey area under the current regime, and so will probably remain so under the new regime. The wholly or mainly funded out of public funds question will probably be the main criteria that universities would be assessing to decide whether they're public authorities. And there's the Cambridge European Court of Justice case from the early 2000s that essentially sets a 50% threshold in terms of funding. So it's not an insuperable question for universities, but it is potentially quite a tricky one. So public authorities, if you qualify as one of those, essentially all your contracts are covered if the contracts themselves are covered by the Act. If you're not a public authority, you may still be a public undertaking. Funding doesn't come into it in terms of whether you're a public undertaking. The question is whether you're subject to public authority oversight. Same test as under public authority, which is why the colour is the same. And you operate on a commercial basis. If you meet both of those criteria, then you will be a public undertaking for the purposes of the Act. And the Act will therefore apply to you, but only, going back up to the top of the slide, for the purposes of utilities contracts. So it's not all of your contracts, it's just utilities contracts. And we will unpack that in a couple of slides' time. The third category is a private utility. So that is a body that qualifies as neither a public authority nor a public undertaking, but it does carry out a utility activity. And in relation to its utilities contracts, it will be covered by the Act. So again, we'll come back to unpack those. But before we turn to utilities, we're going to deal with this final bullet, which is this notion of an excluded authority. So if you might otherwise qualify as a public authority or public undertaking or private utility, but are nevertheless an excluded authority, then the Act doesn't apply to you. And we unpack that on the next slide. So the main category of excluded authority is a devolved Scottish authority, and that is defined as a body or an authority that has functions exercisable only in or as regards Scotland, and none of its functions or only some of its functions relate to reserved matters. Now, for those of you who are procurement specialists, this concept of reserved matters might be new to you. It's all about the Scotland Act and what's within the legislative competence of the Scottish Parliament. As if procurement legislation was not complicated enough, it was thought sensible to introduce into it the even more fiendishly complicated, in some cases, question of whether a function relates or does not relate to reserved matters. But at least in Scotland, authorities tend to have some sense of that. So, but that's what you're looking for. So functions exercisable only in or as regards Scotland, and no reserved matters functions or only some reserved matters functions. Unless you tick both those boxes, you are covered by the Act, and you are no longer covered by the old procurement regime, because all of those regulations are disapplied in respect of anyone who is not a devolved Scottish authority. If you're a public undertaking or a private utility, you will be treated as a devolved Scottish authority and therefore excluded from the Act. If you operate only in or as regards Scotland, and you have no activities that relate to reserved matters, or again, only some of your activities relate to reserved matters. So it's the same principle, except you're swapping functions for operations in one part of the test and functions for activities in the other part of the test. Any person who is subject to public authority oversight only by reference to a devolved Scottish authority will also be excluded from the scope of the Act. And I've underlined only there because if a person is subject to oversight by a devolved Scottish authority and another contracting authority that is not devolved Scottish, then the exclusion doesn't catch them. The final bullet then, other exclusions likely to be much less common, or at least apply to far fewer bodies. So you've got MI5, MI6, GCHQ, the Advanced Research and Inventions Agency, or any person that's subject to public authority oversight by reference to one of those is excluded. And you'll note that the word only doesn't appear in that last bullet. So a person who's subject to public authority oversight by one of those and another public authority is nevertheless excluded. So we'll touch on Scottish authorities again briefly in a moment, but first on the next slide we'll deal with utilities and also concessions. So a utilities contract, that phrase that appeared in an earlier slide, that means a contract for the supply of goods, services or works wholly or mainly for the purposes of a utility activity. Utility activities are defined in the Act. So Schedule 4, Part 1 sets out a number of activities, anything to do with, well, broadly speaking, most things to do with gas and heat, electricity, water, transport, ports and airports, oil and gas extraction or exploration. But there are then other cumulative conditions. So you have to be specified in Part 1, but then not specified in Part 2. So Part 2 excludes, for example, the generation, production, and the wholesale or retail sale of electricity and gas in Great Britain, or the production or exploration for oil and gas in Great Britain. So essentially, the inclusion of those things in Part 1 of Schedule 4 really only matters for the purposes of Northern Ireland. And that's because the markets for these things in Northern Ireland are not deregulated in the same way as they are for GB, which is why they're still subject to a stricter procurement regime. And there are Brexit implications or reasons for that would merit their own webinar. Perhaps redundantly, your activities have to be at least carried out partly inside the UK. If your activities are wholly outside the UK, then the Act doesn't care about those. And then the final condition, if you're not a public authority or public undertaking, so if you're a private utility, you'll only be caught by the Act if your activities are carried out pursuant to a special or exclusive right. And again, this isn't changing the rules from the previous regime, it's just stating them in a slightly different way and in a different place. So a special or exclusive right means that the private utility, either by itself or with others, has been granted a right to carry out the utility activity under a statutory, regulatory, or administrative provision. And that provision also substantially limits the ability of persons not granted the right to carry on the activity. But it doesn't apply if the right has been granted through a competitive process. So this would come up under the old regime, for example, in relation to rail franchises, where the fact of the competitive process for the rail franchise meant that there wasn't a special or exclusive right, and therefore the utilities contracts regs didn't apply. So it's not really a different test, just stated in a different way. And then concessions, similarly, they're also defined similarly to the existing rules, so we're not going to spend time going through the details of those. I said we'd return to Scotland briefly, so on the next slide, recapping, the Act does not apply to devolved Scottish authorities or any persons who are only subject to public authority oversight by devolved Scottish authorities, but that is subject to Section 25A, and that's Section 25A as amended. So if you look at it in its current form, you won't see this bit because it's not yet been made, this change, but presumably will be by the time 28th of October comes around. So this is except where a devolved Scottish authority carries out procurement falling within Section 115A. So again, we're chasing our tail around different parts of the Act. 115A provides that the Act does apply in relation to a devolved Scottish authority where, and I'll read this short, it's effectively participating in a procurement under an RUK procurement arrangement, whether that's Welsh or Northern Irish or English. And essentially what you're looking at there is that under the procurement arrangement, a contract is to be awarded following a joint procurement procedure where you have a devolved Scottish authority and another contracting authority that's not devolved Scottish, or is undertaken by a centralised procurement authority. So in those cases, the Act applies. Or a contract is to be awarded in accordance with a framework or similar arrangement, or a dynamic market or similar arrangement. So if a devolved Scottish authority is looking to award a call-off contract under, for example, a Crown Commercial Services framework that's been procured under the Act, then the provisions of the Act will apply to that process of procuring the call-off contract. We unpack that slightly on the following slide. So a reserved procurement arrangement is any procurement arrangement that's not devolved Scottish, devolved Welsh, or transferred NI. So it's essentially, it's an everything else bucket. So if a devolved Scottish authority or a Welsh or NI one didn't award the framework or didn't establish the dynamic market or isn't the centralised procurement authority or isn't designated as lead authority for the process, then what you're dealing with is a reserved procurement arrangement. And a procurement arrangement itself is a procurement where a contract is awarded under a framework, a dynamic market, or a joint or centralised procurement procedure. So this is all about joint centralised procurements, call-off contracts under RUK frameworks, that sort of thing. If it's a joint or centralised procurement, then the Act applies without modification. If it's a call-off contract that was awarded under a reserved, etc., framework or dynamic market, then only certain provisions apply and some with modifications. So even if you are a devolved Scottish authority, there are nevertheless parts of the Act that you will need to be aware of and may need to navigate. So don't come away from today's session thinking none of this applies to me. Don't dial off just yet, because there are potentially scenarios in which you will need to be conscious of this, and you'll have to be riding two horses in terms of different procurement regimes, which can be tricky. Jamie, over to you.
Thanks, Charles. So that covers who is subject to the rules and when they're subject to the rules. If we move on now to when the rules come into effect, the timings for this are set out in the third set of commencement regulations, and I'll cover them very briefly. The first sort of point to note is that the Act doesn't apply, you would think, obviously, where a contract or framework was concluded before the Act came into effect. That's not necessarily quite as obvious as you would think, because there are a lot of provisions in the Act, and I'll come on to this, that affect the ongoing operation of a contract and not merely its award. So this is an important thing to note. If your contract or framework was concluded before the 28th of October, then none of those ongoing obligations are going to apply to you, because the Act doesn't apply to your particular contract in those circumstances. Similarly, the Act won't apply where an operator was contacted to commence a direct award before the Act came into force. It also doesn't apply where a PIN was published as a call for competition before May of last year. The rules around doing that as a call for competition have changed, but the key point to note is if you started a competition with a PIN notice before May 2023, then the Act won't apply to you. The Act, or to that contract, the Act doesn't apply to a contract where before the 28th of October this year, the contract notice was submitted for publication. I'll come on to what that notice means, but essentially, where the contract notice under the old regs was submitted to the e-notification service, even though the contract itself may or may not be in effect, the Act won't apply. Similarly, if a VEET notice was published, so it's not enough in respect of a VEET notice that it was sent for publication, it has to have actually been published. But in those circumstances, the Act won't apply. And there are also specific provisions for direct awards following on from PCR procurements. So imagine a scenario where you tried a procurement, nobody gave you a satisfactory response, you're proceeding with a direct award. That's caught by certain transitional provisions, and there are complicated ones also for utilities and concessions. But subject to those specific carve-outs, the Act will apply, generally speaking, from the 28th of October this year. So if we move on then to some of the key changes that the Act brings about, some of the key points to get used to, I'll start this with, it will feel very similar, at least at the start and the sort of operation of a procurement procedure. Documents will not be replaced wholesale necessarily. A lot of the general gist of the thing is going to look exactly the same, but there are changes around the edges, and there are a lot of changes in terms of transparency that I'll come on to. So we start with the point around there is now a single set of rules. I've put single in inverted commas because, as Charles mentioned, whilst the Act replaces a previous set of a number of different regs, it applies differently to public contracts, utility contracts, concession and defence contracts, and indeed light touch and below threshold contracts. So whilst in principle it's a single set of rules, really it's a single rule book, but you'll be looking at different parts of the rule book for different types of contract. The principles that you'll remember, those overarching principles of public procurement rules concerning transparency, equal treatment, non-discrimination, and proportionality, those have been replaced with woolier procurement objectives. The key point about procurement objectives is that the duty under the Act is to have regard to the importance of these things. Precisely how far that duty to have regard goes and what that looks like in practice is probably going to be subject to a fair bit of litigation. But the things that you have to have regard to the importance of are delivering value for money, maximizing public benefit, sharing information, transparency essentially, and acting and being seen to act with integrity. Now, the one procurement principle that does survive as a quite clear and freestanding duty is the duty to treat all economic operators equally. So there is still a general equal treatment obligation. That is probably, but that currently is a key place where litigation comes from. It will probably remain so. Some of these other ones are going to have to be ironed out a little bit. There is a new duty to have regard to the National Procurement Policy Statement, and indeed, if you're in Wales, the Welsh Government's Procurement Policy Statement, and similar. But that will effectively be currently being rewritten, I expect, by the newly elected government. We'll see what that looks like when we have one that's ready to go on the 20th of October. There is an express duty to consider lots, although it's no more than that. There have been some suggestions in some quarters that there's a duty to have lots. That's absolutely not the case, nor is there a duty to make everything accessible to SMEs. These are about duties to consider and duties to take account of those things. And the former obligation to award a contract to the most economically advantageous tender becomes an obligation to award to the most advantageous tender. We've got rid of the word economic. What is the effect of that? Well, in practice, in legal technical terms, none whatsoever. The idea of this is to encourage contracting authorities to take more account of broader social value and other considerations rather than focusing on the economic. The legal effect of it stays the same, but this is about encouraging you to take advantage of that freedom to take into account those other objectives. Moving on then, we go from 6 competitive tendering procedures to 2. You can either have an open procedure, which is a single stage procedure, looks exactly like the old open procedure. You won't really notice any particular differences to the procedure itself. You invite bids, you get bids, you evaluate bids. There is then the competitive flexible procedure, which is in effect any other competitive procedure that the authority considers appropriate to the circumstances. So that might look like a restricted procedure, or it might look like a negotiated procedure, or it might look like a competitive dialogue, or indeed one that I was writing this morning is somewhere between a negotiated and a competitive dialogue procedure. And that is something that you can do too, as long as it makes sense in the circumstances. You've got a lot more freedom to design these things. Might make templates a bit harder, but it may also give you more flexibility in individual procurements. Whatever you do must be proportionate to the nature, complexity, and cost of the contract. Instead, in place of the old selection criteria, you now have conditions of participation. The only real change other than the name is that it's quite clear now that you can't require accounts to be submitted or insurance to be in place until award of the contract. And there is flexibility to refine the award criteria during the course of a competitive flexible procedure if you do that before the ITT has been issued and you don't cause prejudice in doing so to any of the participants. Okay, so moving on. Exclusions, excluded suppliers replace mandatory exclusions, and excludable suppliers replace discretionary exclusions. Yes, it really is pretty much just another change to the language. Really, the only key point to note is that there are additional grounds of exclusion for improper behaviour and extended grounds relating to past performance. It will become easier to exclude somebody based on how they have previously failed in a contract, without necessarily getting to the same level that the previous rules had around termination and the like. There will also be, and this is a key change, a central debarment register. So the UK government will operate a central list of everybody who has been debarred from public contracts, and expect a lot of litigation around who goes on that list, how they get off it, and who's responsible for those things. There'll be flexibility to modify a procurement up to the tender deadline in an open procedure, or the participation request deadline in a competitive flexible procedure, subject to a duty to republish the tender notice, albeit there's no particular duty to wait. Having done that before you republish, there's no particular sort of amount of time for people to reflect on that. But you aren't allowed any substantial changes in you can have non-substantial changes up to the tender deadline in a competitive flexible procedure, but not substantial ones. A dynamic market, this is an interesting point, and not just in terms of name. Dynamic markets replace dynamic purchasing systems. It used to be in a DPS, you could only use it for effectively commodity purchases, pencils and tax and the like. Now, they were used for more complex things, and that did cause a lot of confusion. It's now clear under the Procurement Act that you can use a dynamic market for any sort of sophisticated non-commodity procurement that it feels suitable for. The one bar and the one potential issue with dynamic markets appears to be that they may not be capable of being used for below threshold regulated procurements. So that's a category of procurements effectively between £30,000 and the tender threshold, where you are subject to certain duties under the Act. You may not be able to use dynamic markets for them at all. That might be something to be ironed out in secondary legislation, we will see. Frameworks, there's now such a thing as an open framework. So you can continue to have your old style frameworks, but we now call those closed frameworks. We'd really call them frameworks, but we'll call them closed frameworks just now. Up to 4 years as before, up to 8 years for utilities, up to 8 years subject to reopening. And I've mentioned the central register. So the way that moving on to the next slide, the way that the Act approaches standstill is that it's 8 working days instead of 10 days, but it begins with the contract award notice being published, not with standstill letters, which are replaced by something called assessment summaries. Notices, there's a really the key thing about the Act, the biggest change that you will notice is an obligation to publish a notice pretty much every time you blow your nose. From the start of getting involved in public procurement in any process, all the way through to that contract being 5 years in the rear view mirror, you are going to have to publish notices for a lot of different things. And that is going to be a key change that a lot of contracting authorities will have to get used to. There are new implied terms regarding electronic invoicing and payment. And there is a new procurement review unit, the procurement police, as I like to call them, to investigate and monitor compliance, albeit not with any particular powers to enforce or penalise. It's more about investigating best practice. Moving on then to the next couple of slides. Modifications, generally speaking, changes to modification. The modification rules look exactly the same. They're divided up a little bit and they're renamed, but they're very much identical in practice to the existing ones. Key things to note are that there's some additional clarity around de minimis, so value or term changes that are very small. There's generally an obligation to publish a contract change notice, except for certain de minimis value or term changes. You may provide for a voluntary standstill period in a modification notice, but you're not under an obligation to do so. If you do, it has to be at least 8 working days. And there's a duty to publish the contract as modified or the modification if the contract's value is over £5 million. Otherwise, the general gist of what can we modify and what can't we will look the same. Moving on. So the government talks in its guidance documents, those 48 documents Charles mentioned, about 4 phases of a procurement lifespan. Plan and define are the first 2. And I've noted on these slides what the key changes are in terms of those phases of a procurement. I mean, I'll just pick out a couple on this. You'll have the slides. There's an obligation to have an annual pipeline notice if you're planning to award more than £100 million worth of contracts in the next year. In the define phase, preliminary market engagement processes, you now need to give notice before you engage in those. And there are standstill periods for direct awards, which is a change from the situation before. I've mentioned, obviously, the changes to the different procedures and the use of the central digital platform. A key point on this is you must publish first on the central platform. Even if you then use your own platform or a sector platform, an industry platform, you have to go first on the central one. You will have a notice for any framework call-offs, and there is a duty, as I say, to consider lots and lowering barriers to SMEs. On the next slide, the procure and manage phases, key points about the procure phases. There are new duties to publish notices if you terminate a procurement process halfway through it. There is obviously the central debarment register, and publication of the notice starts the standstill period, not the assessment summaries. But essentially a lot of that is going to look the same. There is then this manage phase at the end. This is about how you run your contract. So the Procurement Act is not just about how you choose who wins a contract, it's also about how you then manage that contract, including mandatory contract termination notices and mandatory KPIs in higher value public contracts. So then moving on to litigation and the enforcement of this. Key points here, the duties under parts 1 to 5, 7 and 8 of the Act, which is basically all of the bits you need to worry about, are enforceable by suppliers. They're enforceable by economic operators, including a duty to have regard to those procurement objectives I mentioned, and the equal treatment duty under section 12.2. And that is owed to any UK supplier or effectively any supplier from a country that the UK has a free trade agreement with, including the EU. Proceedings can be brought by anybody who falls into those categories who suffers or is at risk of suffering loss or damage. It must be brought in the High Court, the Court of Session, or the Northern Ireland High Court. Key point about this is that the Court of Session will be hearing litigation brought under the Procurement Act, as well as litigation brought under the existing Scottish procurement rules. So it will be dealing with multiple regimes, but they will all be going to the Court of Session in Scotland, where that is the relevant forum. There's no enforceability for the requirement to have regard to the procurement policy statement. Automatic suspension. Similar, but not the same. Contracting authority may not enter into a contract or modify one if proceedings are commenced during the applicable standstill period and the contracting authority is notified. There will be all sorts of issues to get used to around commencement and notification and so on. Most of that will look exactly the same as before in England, Wales, Northern Ireland. For those contracting authorities in Scotland, this is not the same in terms of trigger points as the existing procurement rules. So you will have to be used to where you're operating under both regimes or where you're operating under this regime. You will have to get used to different points for when standstill is affected and when the automatic suspension is triggered. Remedies look very much the same, and I've mentioned the procurement police force that we all look forward to seeing how they do. So I think that then leaves Charles to take the key takeaways.
Thanks, Jamie. Still some time to put your questions in. We've got some, and we should have time to answer them. So if you have a question to ask, please do so. So the key takeaways, the Act will change how you, if you're a public body, buy things. If you're a supplier, it's going to change how you sell things. Devolved Scottish authorities are mostly going to be bystanders for this. But if you're procuring jointly or through a UK framework, which a lot of devolved Scottish authorities do, you are going to have to be aware of this regime, and you're going to have to comply with it. There is more flexibility, but as Jamie mentioned, there's significantly more transparency. I would pick out in particular the need to be transparent about making direct awards, and the need to be transparent about contract modifications. At the moment, with a couple of exceptions in the modification category, as long as you're content that you're entitled to do those things, you have no obligation to publicize it. So it's essentially, you self-assess, you conclude, well, it's lawful for me to do this, and you do it. And it's probably quite unlikely that anybody who might take issue with that would ever find out about it. Under the new regime, they're very much more likely to find out, because you will have to be putting out notices. A lot of established principles will be relitigated, if only because they are written in a slightly different way. And when you write things in a different way, they can have different meanings, as recent subsidy control cases have established, in terms of probably unintended departures from state aid. Unhappy bidders will need to move even quicker than before if they're bringing procurement challenges. The benefit of automatic suspension is only available during the standstill period now, or will be under the Act, as Jamie mentioned. And the Scottish courts will be handling two types of procurement litigation, which will be a challenge. Our final slide, if we move on to that, there we go. This is a picture of Dagen H, and that is the day in Sweden when it changed from driving on the left-hand side of the road to the right-hand side of the road. Now, I have used this image in the past to talk about transition costs and how even if your new regime is superior to your old one, you still have to take account of any difficulties that might result from the transition. Happily, as a metaphor for the procurement regime, although that looks chaotic, that is actually the very moment 5 a.m. on Dagen H when the Swedes switched from driving on the left to driving on the right, having been forced to be immobile for 10 minutes prior to that. This is that very moment when they're all, in a very Swedish fashion, calmly and without incident, switching over to the other side. So let's hope that the change to the Procurement Act will be very much in the spirit of Dagen H. So we do have time for some questions. Jamie, so I don't spring it on you. Can you deal with the one about the pension scheme and the dynamic market contract? I'll pick up, I'll answer first. Question about any insight on whether the Scottish Government might follow suit. My very strong impression is that they won't. I think the main reason for that is that the Scottish Government has both a policy of and a power to keep pace, and that's the term that's used, keep pace with EU legislation, to essentially stick as close to the EU as possible. And the existing procurement regime and the one that will continue to apply in Scotland is, of course, the EU-derived regime. So I think given the choice between consistency with the EU regime and consistency with the RUK regime, at least the current Scottish Government, I would expect to prioritise consistency with the EU regime. So I don't expect the Scottish Government to piggyback onto the Procurement Act regime, at least this side of the next Scottish election. Jamie, so question, are the trustees of a non-commercial funded pension scheme that is sponsored by a public authority covered?
So high level, if you were covered before, you are probably covered now. Before, with a lot of pension schemes, the key question was around effectively who appointed the trustees, and essentially a question of oversight. I expect that it will be interpreted much the same as before. So yeah, approach it on the basis that if you were subject to public procurement rules before, you were subject to public procurement rules now.
Okay, and then what's the minimum threshold of spend that can be used for a dynamic market contract?
Yes, I like this question. The under a DPS before, you could pretty much award anything you liked on using that DPS if it was within the scope of it. The problem now is for below threshold contracts, regulated below threshold contracts, so between about 30k and about 230k for a services contract, say, those below threshold contracts cannot be restricted to people meeting certain pre-qualifying obligations. And pre-qualifying obligations are a necessary part of a dynamic market. So because you can't have a pre-qualifying rule for a contract that is under 230k but above the below value threshold, you can't use a dynamic market for it. We'll see if that gets tidied up, but it does seem to be potentially an oversight that will impact on how much the dynamic market system is used.
Okay. A couple of questions on thresholds, one for pipeline notice and one for remedies. And then there's one on PINs and the timing of those. I'll answer another question in the meantime if you have a quick think about those ones. So other question we have is about litigation and that point about automatic suspension during the standstill period. So the question is it no longer possible to extend standstill in order to postpone litigation, which I think is often the strategy that a public authority will take if threatened with litigation, offer to extend standstill, take those extra few days to explain to the potential challenger why actually they don't have a case. And in our experience, in most cases, that challenge will go away if you just take that little bit of extra time with the protection of the standstill period and the ability to secure automatic suspension on the challenger's side. They can have some comfort that that time is available to them. So technically, in order to get automatic suspension, you do have to have a standstill period. Having spoken or heard from the civil servants who drafted the bill, their idea is that the the standstill period follows on from the relevant notice. And so you can start a new standstill period by issuing a further notice. So you can't have just sort of an informal undertaking to extend standstill. You would actually need to have that formal notice. So it's just another area where this act is going to result in quite a lot of notices and related bureaucracy. So we're at time, but I do just want to cover these remaining questions. So Jamie, does the pipeline notice only apply to procurements over 2 million?
Yes. So you don't have to, in your pipeline notice, even though everything comes to more than 100 million, you only have to mention specific information concerning those that you expect to award above the 2 million mark.
Okay. Are remedies available for contracts below the Procurement Act thresholds, but above the thresholds for notifiable below threshold contracts? It might be worth just stating briefly what the thresholds are.
Yeah. So the thresholds for higher, what we'll call higher value regulated ones, so the ones that are subject to the full scope of the Act, and the ones that are the same as the thresholds for what is subject to the PCRs at the moment, because those are set out in the UK's international treaties with other countries. So approximate for most public bodies, you're talking 230,000 for services or supplies and 5.3 million-ish for works. The lower value, the below threshold regulated procurements kick in for most public bodies at 30,000 for a services contract, and about at 230 for a works contract. Now, the key point here is, for the keen-eyed amongst you, parts 1 to 5 and 7 and 8 of the Act are enforceable in civil proceedings. Obviously, that leaves out Part 6. Part 6 is lower value regulated procurements. So the specific duties relating to those are not enforceable, and therefore there aren't remedies under Section 100 of the Act. But there is case law that suggests that it would still be enforceable as a question of judicial review. So it's not to say that you can completely ignore those without fear of remedy.
And that's, in case people were wondering, that's the Good Law Project reference that was on one of the slides that we didn't quite have time to get to. That's the case that established that. And then final question, quite technical. Let's pitch it to you anyway, see what happens. PINs after May 2024 are under the new Procurement Act, but contract notices before 28th October are under the PCRs. Does a PIN issued today push the whole procurement under the Act?
No, because you have to issue a call for competition, and a PIN hasn't been capable of being used as a call for competition since May of last year.
Perfect. Okay. Great. If you had any questions that we didn't get to, or that you didn't feel like asking in this forum, then just drop us a line direct. Our email addresses are on the screen and will be in the follow-up email that you receive. So do get in touch if you need anything from that. On our final slide, you can see details of some other upcoming webinars. I've already mentioned the one for contractors and suppliers. So if you're still here on this one and you still haven't had enough, then you can come back for that slightly differently focused version of the webinar. And if you'd like to hear more about procurement and how it might affect your contracts, Jamie will be participating in our more generally themed commercial law update towards the end of the month, which is a twice yearly update for in-house lawyers, procurement professionals, and anyone who negotiates or manages commercial contracts has responsibility for procurement, IP, data, consumer protection, regulatory compliance, that sort of thing. So this webinar is going to look at developments that might impact on how commercial agreements are drafted and negotiated, and that will include the consequences of the new Procurement Act. So won't keep you any longer. Thank you very much for your time and hope to hear from you soon. Bye.